In Module 6, we'll discuss crimes against the community and public order. This is part one of the lecture for Module 6, in which we'll talk about white-collar crime. Our sources for this module will be our textbook, Criminal Law for Criminal Justice Professionals, as well as Louisiana Revised Statutes Title 14 and Louisiana Revised Statutes Title 40. Our learning objectives for Module 6 will be to define the types of white-collar crime, explain the distinctions between the most common traffic offenses, define the offenses of the public morality, list the major categories of controlled dangerous substances, and explain the elements of driving under the influence or driving while intoxicated. There's several crimes that fall under the category of white-collar crime. The first one we'll discuss is what's known as tax evasion or tax fraud. This is the willful attempt to avoid paying any taxes that are legally due, either at the federal, state, or local level. There's three elements to tax evasion. The first element is that there be an existence of a tax deficiency. This occurs when the proper amount of tax owed is greater than what's shown on the defendant's tax return. For example, a defendant may owe $10,000, but the taxpayer, the defendant, manipulates his or her tax return to indicate only $8,000 is owed. So there's a $2,000 deficiency. The government has to prove that the defendant received income in addition to what was reported, and that unreported income was taxable. This element can be proven with direct evidence through the use of the tax return itself, bank statements, check stubs, and the like. So that's an examination of the records, like specific items as a specific item method, and then there's circumstantial and direct evidence, like what's known as the net worth method, the cash expenditures method, and bank deposits method. The second element is an affirmative act, that the accused performed an affirmative act to evade or attempt to evade taxes. This is a critical element between a misdemeanor conviction and a felony conviction. We're talking about the difference between just simple neglect to file a return and what constitutes a serious felony, which is the evasion of taxes. Some examples would be filing a false tax return, keeping a double set of books, concealing assets, placing assets in another name, or lying to the IRS. This would constitute an affirmative act. The third element of tax evasion is willfulness. This is the voluntary, intentional violation of a known legal duty to pay taxes. For example, the taxpayer knows that he or she should have reported more income. The government has to show that the law imposed a duty on the defendant to pay the taxes. The defendant knew of this duty, and the defendant voluntarily and intentionally violated the duty by evading the taxes. Some defenses or to tax evasion, or what's called the cash hoard, where the defendant has a substantial amount of cash on hand, or underestimates the amount of cash they have on hand, or doesn't know how much cash they have on hand. And against willfulness defense is the defendant simply states they had a lack of knowledge that the taxes were underreported. And then they can also use a third-party defense. They can blame their accountant or attorney for preparing the returns that underreported income. Another type of white-collar crime is false advertising. False advertising has both criminal and civil liability. And under the federal law, two particular acts have dealt with false advertising. The Trademark Law Revision Act stated that anyone that damaged by false advertisement can sue the advertiser. This particular law considers the rights of competitors, not consumers and non-competitors. The Federal Trade Commission Act dealt with using the mail or other means to induce the purchase of food, drugs, devices, services, or cosmetics through false advertising. Some states have false advertising laws as well, and these are mainly to protect consumers. In terms of state law violations, the false advertisement must be material and there be proof of intent to sell the product to consumers. Mail fraud is another type of white collar crime. It's the use of the mail service to disseminate materials that deceive others. Four elements of mail fraud include there be a scheme to defraud. A scheme is not particularly defined in statute, so wide discretion is given to both prosecutors and judges to determine if a scheme existed. There's no requirement that the scheme be successful or completed, merely the planning of the scheme. That money or other tangible property through misrepresentations or omissions be a part of that scheme. The second element is having the intent to defraud, that the defendant intended to defraud the victim through the scheme that was established. Mail fraud requires that there be a use of the United States Postal Service or private interstate carriers of packages and mail like UPS, FedEx, DHL, and others. And there must be a furtherance of the scheme to defraud. You must prove that the mail was needed to execute or complete the scheme to defraud. Securities fraud is another white collar crime. The Securities Exchange Act of 1934 at the federal level is the most widely used statute in the prosecution of securities fraud. Securities fraud can be have a criminal penalty, civil responsibility, or even administrative responsibility. There are four elements to securities fraud. Number one, there be a substantive fraud in terms of material omissions or misrepresentations. The defendant made a false statement or omission that's material, that it's made with knowledge, that it caused the injured party's damages, and that the defendant had a duty to disclose the information, which would form an omission if they did not disclose that information. Another type of substantive fraud is insider trading. This is the purchase and sale of securities based on material, non-public information. A publicly traded company on a various stock exchange, you can't use information that the rest of the public is not privy to enhance and purchase or sell stocks based upon that information. But this does raise questions about who are insiders. Does it necessarily need to be a member of an organization, member of a company? Could it be a member of the board of directors or an influential stockholder who's not a member of the board of directors? Parking is another type of substantive fraud. This is when the sale of securities occurs with the understanding that the seller will repurchase the securities, repurchase the stocks or bonds at a later time. This is used to manipulate supply and demand of stock, circumvent any margin rules for paying at the margin, and avoid the reporting of sales. A broker-dealer fraud is another type of substantive fraud. This is when excessive stock purchases occur without regard for any type of objectives that the client might have for their stock portfolio. A second element of securities fraud is that the fraud is found in the offer, purchase, or sale of a security in connection with a sale. The offer for sale means that every attempt to offer to dispose of or solicit an offer to buy a security or interest in a security for value. The purchase is any contract to buy, purchase, or otherwise acquire a security. The third element is that there be the use of interstate commerce or the mail system. This need only be an incidental act if it's in furtherance of the fraud. And then the fourth element is willfulness, and we've discussed willfulness as an element for many crimes. There's a few defenses to securities fraud, including a no knowledge defense, that the defendant didn't know the actions were contrary to any laws. A good faith defense, and this is when the defendant believes that misstatements were true or omission was unintentional or immaterial. And then the third defense is a reliance on counsel, that the actions were based on the advice of the defendant's attorney. Crimes against the Food and Drug Act, there's certain prohibited acts within these crimes. The introduction, delivery, or introduction into the interstate commerce of any type of food, drug, device, or cosmetic that's adulterated or misbranded. The adulteration or misbranding of any food, drug, device, or cosmetic within the interstate commerce. The receipt in interstate commerce of any food, drug, device, or cosmetic that's adulterated or misbranded, and the delivery thereof for pay or otherwise. There's also a prohibited act within this crime in which the defendant may refuse to permit an inspector to enter in order to inspect or actually prohibit or impede inspection of any food, drug, device, or cosmetic. And then finally, the manufacture within any territory of any food, drug, device, or cosmetic that is adulterated or misbranded. The four elements of a crime against the Food and Drug Act include that it actually must be a food, drug, cosmetic, or device. Food includes articles used for food or drink by humans or animals, chewing gum or components of any articles. A drug means anything used for the diagnosis, cure, mitigation, treatment, or prevention of disease in humans or animals. A cosmetic is intended to be rubbed, poured, sprinkled, or sprayed on, introduced into, or applied to the human body. And a device is any instrument, apparatus, implement, machine, contrivance, implant, in vitro reagent, or other article, including their components. The second element is the object has to be adulterated or misbranded. Adulterated means the ingredients are poisonous, filthy, putrid, or otherwise unsanitary, or have been contaminated. And then misbranded means the branding of food, drugs, cosmetics, or devices that are false or misleading, including the information labels, any packaging, or containers. The third element is that the object must be introduced into interstate commerce. This isn't limited to actual transportation of articles across state lines, rather the entire transaction. The fourth element is when the defendant is a corporate officer, the officer must bear a responsible relation to the violation. They actually had the ability to commit the violation. And any prior FDCA violations make it a felony. That what the defendant had the intent to introduce the articles into interstate commerce, and the defendant has a prior violation and is doing so again. Some common defenses for FDCA violations are that it's a Fourth Amendment violation, a protection from unreasonable search and seizure, and that the act was actually impossible. If it's objectively impossible for a corporate officer to prevent or correct FDCA violations, then there's no liability, meaning that the corporate officer lacks the authority the resources or the ability to commit the crime. Other white-collar crimes include antitrust and monopoly crimes. Antitrust laws protect trade and commerce from restraint, monopolies, price fixing, and price discrimination. These types of statutes ensure and preserve a competitive economy and prosperous free enterprise and equal opportunity. Some key federal laws in the antitrust arena are the Sherman Act, which criminalizes unreasonable restraints on interstate commerce, criminalizes monopolies or conspiracies to monopolize through any unfair practices. The Robinson-Patman Act prohibits the sale of goods at unreasonably low prices in order to destroy competition. So this act deals primarily with pricing. The Clayton Act prohibits activities that harm competition, such as exclusive dealing arrangements and mergers to damage competition. And the Federal Trade Commission Act prohibits unfair and deceptive practices. Price fixing is one of these antitrust crimes. It is an agreement to raise, lower, fix, peg, or stabilize commodity prices entering into interstate commerce. You have a horizontal price fixing, which agreements are made between market participants at the same level in a market. And then vertical agreements are made between market participants at different levels in the market. Market allocation agreements are those types of agreements that are made between competitors within a given market to divide up markets by territory, product line, or customers in an effort to minimize competition. Boycott is a concerted refusal by traders to deal with other traders. And a tying agreement is an agreement that a buyer must buy additional or tiered products along with the one product that he or she desires. Price discrimination is defined as an effort to unfairly eliminate competition by another manufacturer or unfairly causes one or more customers to go out of business. A monopoly is defined as the obtaining, the joint acquisition, and maintenance of the power to control and dominate interstate trade and commerce in a particular commodity to such as an extent that they are able to, as a group, exclude actual or potential competitors from a particular market field, accompanied with the intention and purpose to exercise such power. So there's two elements to the crime of a monopoly: the possession of monopoly power, including the power to control or fix prices, and unreasonably restrict or exclude competition from a relevant market, and the willful acquisition or maintenance of that power through unlawful means, and not from having competitive business practices. So this is the end of Module 6, Part 1. We'll move on to Module 6, Part 2 in our next video.